So, just over a week ago up at Waitangi, the Independent Constitutional Working Group, Mātike Mai Aotearoa, presented a report that explores Māori views on constitutional change and constitutional transformation. And the report suggests that Te Tiriti can be understood in the context of Māori legal, a Māori legal and constitutional system. And for example, it points out that in the hundreds of years prior to 1840, the common landmass that made up the islands of Te Ika Maui and Te Waka Maui was occupied by distinct iwi and hapu polities. Each polity exercised its own mana and lived according to its tikanga, secure in both its political independence and its whakapapa-based interdependence with others. So there's a history of constitutionalism and diplomacy that exists, and that approach, by the time of the signing of the treaty, and that approach, I think, points to a context for understanding Te Tiriti o Waitangi and for understanding the legal interpretation of the treaty that's not framed by state institutions, so not framed by the courts, the Tribunal, Parliament and the executive branch of government, but instead sees Te Tiriti as a Māori legal mechanism which protects Māori rights that are sourced in Māori legal traditions. And really the key point that I'd like to pick up on here is that seeing the Māori law context there helps us to understand Te Tiriti as an instrument that connects rather than amalgamates state and Māori visions of law and peace. Now, I was going to talk a little bit about the Waitangi Tribunal's report on the Northland Inquiry, which looks at the Declaration of Independence, e whakaputanga, and also Te Tiriti o Waitangi, and both the Māori and English texts of those. And I guess really the key point that I want to look at there is that the Tribunal, in that case, I think in that inquiry does a really good job of looking at they look at a range of sources and hear evidence from a range of different experts to identify what it was that the rangatira who signed the treaty in February in 1840 in the north would have understood or might have understood by that action what was happening. And the essential conclusion, as many of you will be aware, that the Tribunal came to is that those rangatira did not cede their sovereignty in February 1840. And the Tribunal says by that they are saying that they did not cede their authority to make and enforce law over their own people and within their territories. Rather, they agreed to share power and authority with the governor. They and Hobson were to be equal, although of course they had different roles and different spheres of influence. And the detail of how this relationship would work in practice, especially where the Māori and European populations intermingled, remained to be negotiated over time on a case-by-case basis. And I think that captures the expectations of the rangatira in terms of what was going on in the signing of the treaty quite nicely. So I think that's a really important starting place, but I don't think that's where the discussion of what Te Tiriti means in a Māori law context ends, because I think taking Māori views into account when interpreting the treaty is, well, obviously sensible and positive, and as I say, I think the Tribunal does a pretty good job of assessing what those rangatira in the north in 1840 would have understood by the terms of the treaty. I don't think that's quite the same as seeking to use Māori law to give meaning to the treaty, and particularly in terms of giving meaning to what the treaty how it might apply today. And probably, again, just to summarise where I'm coming from with this, I think that if we look at the tikanga context, at the Māori law context, one of the things that we see is the centrality of relationships within Māori law. And so it would seem to me that one of the key parts of understanding the treaty in that Māori law context is to focus on the maintenance of the relationship and the relationship that's at the heart of the treaty. And although thinking about the treaty as being all about relationships is nothing new or revolutionary, I think it does start to suggest something of the kind of subtle shift that Natalie had talked about in terms of some of the partnership-based mechanisms that are coming out of the treaty settlement process. But as I'd like to suggest, I think what still remains problematic is that the treaty settlement process itself is not very good at taking account of that kind of Māori legal framework. So I think it's the treaty settlement process is very much still focused on trying to understand and interpret the treaty, filtered through the state institutions, and trying to find some kind of common agreement on what the terms of the relationship are. And I think actually if we can accept and embrace a little bit of disagreement here, we can focus on actually what it is we need to do to maintain the relationship, and that's what I'd suggest as the kind of central focus of a Māori legal frame analysis of the treaty. So what it is that we need to do to give effect to Māori visions of law and peace, as well as, of course, the state's visions of those things as well. And that means that Māori and the Crown, I think, you don't need to agree on what the exact parameters of tino rangatiratanga is, so long as there's a commitment to the continuing relationship, so long as, in Māori terms, there's a recognition of the mana of each other. So under that kind of approach, you wouldn't get into a situation where the Crown is defining or constraining tino rangatiratanga, and the discussion would be one where both parties kind of are able to set out what they require for their own visions of law and peace. And maybe you could use kāwanatanga and tino rangatiratanga as proxies for those ideas if you wanted to. But it doesn't necessarily mean that there wouldn't be conflict around how you implement those visions. But it suggests a different way, I think, of approaching that conflict and finding the resolutions to them. So in many cases, it ought to be a much more collaborative focus, because if you're looking at strengthening the partnership rather than a positional idea about trying to define precisely or defend your authority, instead to look to what is needed to maintain the relationship, what is needed to give effect to each other's visions of what law and peace might be, then it ought to lead to a much more collaborative approach. Now that might in some ways seem like quite a subtle distinction from the kind of partnership framework that we've become used to in terms of the Treaty of Waitangi relationship, but I think it really does reflect exactly the kind of thing that Natalie's talked about, that you start to see where you have models which are working well, that is the kind of collaborative approach you take. My concern is that the treaty settlement process itself is problematic because it doesn't necessarily build in that kind of collaborative approach at all. In fact, it's very much one which is focused on the Crown visions of law, peace, and certainly an idea of getting certainty for the Crown. So the treaty settlements, often the negotiations become focused on quite peripheral matters, really. They become focused on things like which properties are going to be transferred as part of the commercial redress of a settlement, rather than thinking about actually how to assess the value of the commercial assets that might be required to provide redress for treaty breaches, or if you're focusing on the relationship, what is going to be required to maintain that relationship. You get to discussions around sort of how many statutory acknowledgements or other kinds of cultural redress instruments will be appropriate in a settlement, rather than actually trying to focus on what are Māori trying to achieve through these settlements and figuring out what are the appropriate mechanisms that can do that. As I say, maybe we're starting to see a little bit of a change with that in some of the recent settlements. I think the Whanganui River settlement is probably the outstanding example of where we are starting to see that kind of shift that Natalie talked about. So I've been using the idea of Māori visions of law and peace to kind of deliberately draw a connection with Rob Williams' ideas that he talks about in his book on Indian treaty making, American Indian treaty making, and linking arms together, American Indian visions of law and peace from 1600 to 1700. And Robert Williams concludes in his book with the suggestion that the actions that Native Americans took in the encounter period in terms of developing treaty diplomacy, quote, speak with insight and imagination to the challenges of creating a society in which different, conflicting groups of people learn to trust each other enough to place their lives in each other's hands. And according to American Indian visions of law and peace, they must first agree to link arms together. And I'd like to suggest that we ought to be reframing our understanding and interpretation of Te Tiriti in a legal context by looking at it through that Māori law lens, and that by doing so we might see that actually agreeing to link arms together is the most important step in both the Māori and the Crown achieving their visions for law and peace. Kia ora koutou.